Hi, I'm John Bryan, West Virginia civil rights lawyer, and little John and I just got back from the West Virginia state capitol where we had oral arguments today in our latest case against the governor, the latest lawsuit against the governor based on the disenfranchisement that has happened to the local voters in Wayne County, West Virginia, because the governor wanted his guy in there instead of them having a say in the process. Here's an excerpt from the oral arguments today before the Supreme Court. All right, I have just a couple minutes to hit a lot of points. I have responses to all of that, but perhaps the most important thing is the statement by Ms. C that it's, quote, critically important that District 19 has representation. Well, that's the whole reason that we filed this case. That's why we're here today. The fact is that the District 19 committee members, and there's only 4 of them, all participated in that first list. The man ultimately chosen by the governor was not on that list, was not chosen by those 4 members. That's what it comes down to. That's why we have local people who know the candidates, who know the people who've been involved in party politics that are making these decisions.
How was the makeup of the committees different? I mean, the members of the committee in both instances had to be from Delegate District 19. So how was the makeup of those committees different?
That's a great question, Justice Hutchison. There were 4 District 19 committee members. Now, there are 5 magisterial districts in District 19. There were vacancies that had not been filled. Therefore, there were 4. That was the total number of District 19 committee members. All of them convened to make the first set of choices. At the second meeting, that was called by the acting chair of the state GOP, and that was run by the acting chair of the state GOP, there were only 2 of those same committee members there, one of whom was apparently contacted by one of the state or national party members and asked them to be at this second meeting. So the second meeting had only 50% of the committee members who were at the first. And that brings me to just a really important point here, and that is, I think they've tried to muddy the waters here on, well, what is District 19 committee? It's just this, no one seems to know what it is. Well, there's no dispute. There are only 4 District 19 committee members. There's no dispute as to who those individuals are. They were the 4 individuals that voted on that first list. And they're elected or appointed out of Wayne County at the local level. And what are they members of? What organization are they members of? They're not members of the State Executive Committee. They're not members of the State Executive Committee. In fact, we can look at the state's bylaws and—
Well, that doesn't answer my question. My question is, how were the makeups of the panels different? Were both panels comprised of District 19 committee members?
The first meeting was comprised of all 4 District 19 members who are members of the Wayne County Republican Executive Committee.
Who was on the second one?
There were 2 of those 4 that were at the second.
How many total members were on the second panel?
Only 2. And in fact, if you look at the Wayne County bylaws, and surprise, Wayne County is a separate political party executive committee, completely separate, independent, not a subcommittee. They have their own bylaws, and their bylaws require 3 for a quorum. Therefore, the only 2 members that were at that second meeting did not consist of a quorum under Wayne County's own bylaws. So one thing we know for sure, despite the confusion of who the District 19 committee consists of, we know it's not the State Executive Committee. We know it's not the State GOP. You can look at their bylaws. It's, Article 2, Section 1. It says this is the body of the State Republican Party Executive Committee. Nowhere in there does it list any delegate District 19 members. They're not even a member of the state executive party. They are only members of the county, of Wayne County Republican Executive Committee. That's why, Justice Walker, you brought up the prior times that this happened. I think perhaps the most important one to look at is 2010, when this same acting chair, Roman Stauffer, who was involved in this matter, he was previously in 2010 the chairman of the Mercer County Republican Executive Committee, and in our supplemental appendix to the reply brief, I included every document I could find pertaining to the two appointments that then County Chair Stauffer made or presided over in 2010, one of which was Bill Cole. And you can look at the correspondence setting those up, the meetings, the minutes of the meetings, and the press releases. And it clearly states that it was the Mercer County Republican Executive Committee, headed by and presided over by Chair Stauffer, then, who sent the list of 3 to then Governor Manchin. And if you look at the...
Council, your time has expired, and we have reviewed the supplemental material very carefully. If you would like to conclude, this has been a very well-argued and brief case on an expedited manner, but I appreciate it.
Can I ask one question just on what you just said real quickly? Yes. In the 2010 situation, was the bylaw section that's been cited here, the state committee bylaw, was that in effect at that point? The provision that says that Article 6, Section 4 of Article 6, was that in effect at the time in 2010, or was that subsequent to that?
No, and that's a great question, Justice Armstead. My understanding is that the state GOP amended their bylaws in the summer of 2020 to purportedly give themselves control over the nomination for legislative vacancies. It was not found anywhere in the state GOP bylaws prior to the summer of 2020, nor is it currently found in the state Democrat Party bylaws, because to do so would be very problematic, because that's essentially altering West Virginia Code 310.5, and that's exactly what you're not allowed to do under, 3111. It says, this is part of our body of election law that says no state executive committee of either party, of any party, can use its own internal bylaws to change existing West Virginia code. And that's what they've attempted to do, is they use this 1964 case, State ex rel Zagula, and they actually put it in their bylaws in a footnote, and it says that, look, this 1964 case says that we can do whatever we want to the local and legislative district committees, and the court's not going to mess with it because that's an intra-party dispute. And that's what they've claimed here. And that's not an intra-party dispute. They're trying to change state law. The Zagula case had to do with the same county executive committee. I think it was Hancock County. It involved a guy named John Bryan, who they were suing to get John Bryan off of that ballot, or maybe it was vice versa. But it had to do with a new board basically changing the result of the choice of the last board from the same committee. And the court expressly made a distinction that this is not involving 2 different committees. And that's the big distinction here. This is involving not an intra-party dispute. This is one political party committee that is elected by Wayne County voters being engaged in a power grab or attempted control by the state executive committee that has no direct connection to the local Wayne County voters. And that, I would argue, to conclude my arguments here today, is the whole point, that they ended up not with somebody that they voted for or necessarily even knew that's now sitting in the seat, but they ended up with somebody that, according to the records, donated to Governor Justice when he ran for office in 2016 as a Democrat.
I think we understand your point.
Thank you.
In your argument, again, this case was very well argued and briefed on an expedited matter. It will be submitted.
So it's about a 2 hour and 15-minute drive from here at my headquarters to get to the state capitol. So we're on our way home, myself and Little John, and we start getting messages from reporters to comment on the order. Apparently the court has already issued a decision, and their decision ruled in favor of the governor and denied our petition. And it's going to be explained in apparently a subsequent written ruling. So we don't know what the basis is, but it's just so disappointing that it's just par for the course of just everything that's happened since, February, March of 2020. And that's basically state governors across the country have done whatever they want, have disregarded whatever laws were already on the books. And there's hardly been any court in the land who's been willing to engage in the concept of judicial review and stop these executive branches from violating the laws. And the whole point of the judiciary is, as we were told in the very first case of Marbury versus Madison that you learn in law school, is the concept of judicial review and checks and balances and separation of powers and separate but equal. But we know that since February, March of 2020, all that is in the trash can. I mean, and hopefully we get an order that rules against this on some sort of technicality, but maintains the integrity of the law as it's supposed to be, that the voters get a voice in who their legislator is, and not the governor getting to put somebody who donated money to him and somebody he likes in that position, because that's exactly what happened in this place. In this situation. And I thank you, for all the people that were out there supporting us in this case. The little guy lost again in this situation. And the establishment won. The establishment Rhino Republicans won. And it's unfortunate. But let not your heart be troubled. It's not over. There are a lot of people that are on the side of the people here, who are working hard behind the scenes. This fight continues, maybe not in this case, but this fight continues because now it goes to the legislature, and it also goes to control of the Republican Party and who's going to be and have influence going forward, who's going to control the Republican Party going forward. The constitutionalists need to take control of that party. And maybe that's what the Supreme Court decision is going to say, is that, look, you guys need to handle these party disputes between yourselves. And although I don't agree with that, if that's what the ruling is, there was some discussion of that. That does need to happen. There needs to be involvement in this party process. You can't just complain about the party, either party, if you haven't been involved and if you haven't been paying attention. If you're not paying attention, while the parents are away, the kids will play, and that's been happening for a long time, not just in West Virginia but elsewhere. And it's time to get involved in these local party and the state party decision. It's a time to get involved in the legislature, because you can't count on judicial review. You can't count on that at all. So, I'm really disappointed in the outcome. I tried as hard as I can, and that's all I can do. In the end, it's up to the courts. So, we'll go on to fight another battle, and the war continues.